We're going to be talking about restraint of trade and confidential information. The first thing we need to think about is, what is a restraint of trade? Restraint of trade is a restrictive covenant that restricts your employees from doing something later, or of course now in the employment contract. For instance, you might restrict them from moonlighting with a competitor, or you might restrict them from actually going and working for another competitor. You might restrict them from encouraging your employees to leave your business, or you might restrict them from openly talking to your stakeholders. So there's lots of things, and you can restrict them for, employees want to have no restrictions at all. Employers want to restrict for the universe for an infinite amount of time. So there's always going to be conflict. The other thing to think about is confidential information. Now, in my view, these go hand in hand. Two really complex areas of employment law, but and in some senses quite different, but they work often in unison. So you might have an employee that has a restraint of trade, which really isn't very enforceable, but they've done something that's breached confidentiality, so that's what you're going to catch them out on. So confidential information is where your employee has got access to information that's not in the public environment that you don't want them to use elsewhere, and perhaps they may have done so. So we need to think about how to protect your interests there as well as your interests in restraint of trade. Is it unreasonable to extend my employee's restraint of trade to an entire state? Look, it depends on what you do. If you are a hole-in-the-wall cafe owner, then it's probably going to be unreasonable to tell your employees that they're restrained from working in a cafe in Queensland or in New South Wales or in South Australia, for example. But you might be reasonable to say you can't work within a kilometre vicinity radius. So it does depend. You might be a multinational business, so you're all over the country. Your employees been working primarily in the Queensland region, and you don't actually care if they go out to New South Wales because they actually don't know any of your clients out there or who they are, so just good luck to them, but you're going to restrict them for Queensland, and that makes a lot of sense as well. So it does depend quite heavily on what is it that you do. I do not have a restraint of trade clause in any of my employment contracts. How can I bring one into effect without amending and resending all employees an employment contract? It's going to be really tricky for you to do that. Restraints of trade, in my view, are material changes in your employment, in your working conditions. So basically the law states that your employee doesn't have to agree to material changes in working conditions, and it also goes further and says you must get written permission from your employee to make those material changes. So look, if you don't want to change their employment contract as a whole, I can understand that. If you want to add in a restraint of trade into their employment conditions, you're going to need to get it in writing, and you're going to need to get them to sign it. If they're refusing to do so, there's not much you can do lawfully. We can talk about negotiations, and we can talk about reasonability, and we can try and assist your employee to come to the decision that they should be signing that agreement, and we can probably give them some incentives to do that. But you cannot adversely treat them while they're exercising a workplace right. This is basically a breach of their general protections. So be very careful about how you're interacting with your employee and whether you are threatening them for some reason and making them feel fearful for their job, because that might be a general protections matter. But certainly you can amend the employment contract without changing the whole thing. You would just write a letter telling them that you wish to insert X clause into their employment conditions, and will they approve it. Aside from poaching clients, can I restrict an employee? What can I restrict an employee from doing? Well, there's a load of things you can restrict your employees from doing. You can restrict them from discouraging other employees to leave, like I said earlier, from using your suppliers and such things. But it's often a really good idea to be really industry specific about this. If you want that restraint of trade to stick and you want to be able to sue on it later, then make it specific to the actual job that person is doing. You don't have to make it specific to the actual individual, but the individual's job. And that will make a lot more sense to the courts, and it will give you much more scope to reduce that clause into what you want them to not do or what you prevent them from doing. So if you have to put an injunction in later because they've got up to mischief, it's going to be so much easier for you to do that. Now, you need to understand that restraints of trade and confidentiality agreements are the most, in my view, complex areas of employment law. There's a lot of things that go into it. We talk about public policy, we talk about construction of the documents themselves, we talk about implied conditions, we talk about good faith, we talk about goodwill. We talk about all sorts of things in these, and it really makes a difference on how they're drafted and for what purpose they're for. To have a restraint of trade that actually is, you can argue in a court, you need to make sure that you understand what the person was doing before they left, you understand what they were doing as they were leaving, and you need to understand what they're doing now, so we can really narrow down the breach and get that injunction in place and get that restraint of trade over the line. Thanks for watching.